Hello and thanks for joining us on your channel of choice, Africa Independent Television AIT. It is time for the signature show, your show that matters. It is always a pleasure to have you invest your time with us. I am Marvelous Obonman. Now in this edition of the program, Supreme Court, who is dragging the Temple of Justice into political incantations? Uncollectible PVCs, fuel scarcity, scarcity of cash, threats to pull out of the election. The signs are not good. The Nigerian police, citizens and human rights. Any lessons from the End SARS protest? Priests to offer their blessings to same-sex couples. What shall we not do in the name of God? Plus, thank you. A full package you will not want to miss. Please stay with us.
A new day has finally come for citizens with disabilities in Nigeria. You can now participate in the electoral processes without any worry whatsoever. The new Electoral Act of 2022 has made robust provisions to ensure persons with disabilities are not left out of the electoral process. The Disability Act and the Electoral Act has mandated INEC to provide special assistance for citizens with disabilities at the polling booth. As a citizen with a disability, you are entitled to non-discrimination, priority voting, braille ballots for the blind, magnifying glasses for albinos, election day instructions to support the deaf, among other provisions. So, when you arrive at your polling unit on election day, all you need to do is present yourself to the polling officer in charge and you will be given the required support. It is your right by law. Now, nothing can stop you from being part of the electoral process. You are a citizen, and with your voter's card, you are one of the owners of Nigeria. Go out and make your voice heard as we recruit those that will serve us on election day. This message is brought to you by the Campaign for Equal Voting Access, a program of the Center for Citizens with Disabilities, with support from MacArthur Foundation.
Let me begin this program by expressing a worry and a deep sense of disappointment to an incident that has brought embarrassment to religious institutions, sparked public criticism, and has raised a question on what is happening to our values as a human society. Last week, Thursday, the Church of England's governing body endorsed plans to allow priests offer blessings to same-sex couples. In a General Synod meeting comprising of about 441 bishops, clergy, and laity, 250 supported the same-sex marriage, while 181 opposed, and 10 abstained from the vote. Well, first, let me salute the 181 bishops who opposed this move.
The Church of England is in a new place, and I'm really pleased with the decisions we've made. So it means that once these prayers are formally commended later this year, that faithful, stable Christian couples in a civil marriage or a civil partnership can, if they wish, come to church, and that their love for each other in that relationship can be acknowledged, celebrated, and the couple can receive a blessing. That's never happened before. I'm pleased about that.
There isn't a consensus for same-sex marriage, and so our focus is on the motion today. And what we want to do is to be able to listen to Synod, to further develop the prayers, so that by summer, somebody who is in a same-sex partnership can come into church and have prayer to celebrate their relationship and to have our prayers for God's blessing.
The church is known for protecting, preserving, and upholding morals. Good conscience helps to maintain balance in the society, admonish good behavior, and foster cordial natural human relationship. Now, how did the decision by the Church of England help to service the mandate of the church as provided by the Holy Book? In fact, I have checked both the Holy Book and the Holy Quran. There is no place it is recommended for same-sex marriage. Why has the Anglican Church in England decided to dabble into such practice, not backed by the very scripture that it is the foundation of the church? Last week, the Supreme Court, in two separate rulings, may have sown the seed of confusion in the polity. The case between the ruling All Progressives Congress and Bashir Machina in respect of the Yobe North senatorial district ticket and that of 3 APC northern governors who want the court to stop the deadline given by the Central Bank of Nigeria for the old Naira notes to be legal tender. The Apex Court, in its rulings in these cases, has left many wondering if law, its application and interpretation are mere mechanics without humanity or spirit. Machina is losing his ticket, not on account of not winning the contest, but on account of complaining the wrong way. And Ahmed Lawan is to wear the belt of a boxing contest, for which he never stepped in the ring or threw any punch. Is this a victory for democracy?
What happened was democracy at work, and the courts gave their various judgments, and of course the Supreme Court gave the final judgment. I want at this point to commend the Supreme Court and in fact the judiciary generally for making this kind of judgment to strengthen our democracy.
This is the Signature Show on AIT. We'll take a break and return shortly. Please stay with us.
A new day has finally come for citizens with disabilities in Nigeria. You can now participate in the electoral processes without any worry whatsoever. The new Electoral Act of 2022 has made robust provisions to ensure persons with disabilities are not left out of the electoral process. The Disability Act and the Electoral Act has mandated INEC to provide special assistance for citizens with disabilities at the polling booth. As a citizen with a disability, you are entitled to non-discrimination, priority voting, braille ballots for the blind, magnifying glasses for albinos, election day instructions to support the deaf, among other provisions. So, when you arrive at your polling unit on election day, all you need to do is present yourself to the polling officer in charge and you will be given the required support. It is your right by law. Now, nothing can stop you from being part of the electoral process. You are a citizen, and with your voter's card, you are one of the owners of Nigeria. Go out and make your voice heard as we recruit those that will serve us on election day. This message is brought to you by the Campaign for Equal Voting Access, a program of the Center for Citizens with Disabilities, with support from MacArthur Foundation.
Before we went for that break, we were discussing the Supreme Court ruling on Ahmed Lawan and Machina's case. We spoke to a lawyer for clearer understanding of the Apex Court's ruling. Please stay with us.
The important thing to note is that the whole idea of electoral dispute adjudication, or even the determination of cases by the courts, is to arrive at justice. And the idea of justice is not about technicalities. It's about the substance, substantial justice. And that raises a very fundamental question. What is the province? What is the overriding goal? What is the objective of electoral dispute adjudication? If I may provide an answer, in consideration of the democratic principle of one man, one vote, one woman, one vote, It is an exercise or an inquiry by the courts to determine who got the mandate of the electorate. If it's a general election like the presidency, all those who are entitled to vote. If it's a senatorial election, those who are entitled to vote. If it's a primary, it's about all those who are entitled to vote, whether it's a delegate system or where all registered members of that party are entitled to vote. Who got the majority of lawful votes and made the legal or constitutional provision in respect of that particular election. So that is what the inquiry by the court should be about. It is not academic or intellectual gymnastics about a judge or judges being able to show how much of legal technicalities they know, because that will mean supplanting the question that they will have answered, the main question for determination, with another which has no relevance to the overriding goal and objectives. So if the question was who actually won a primary in a particular senatorial seat, you must come to that determination if a primary was held. Who got the majority of lawful votes and made the legal requirement? It is not about now employing technicalities. A council started a process, okay, with an originating process that was not the right one. He should have come by way of writ of summons instead of originating summons he used. In essence, you are punishing the litigant for the sins of counsel, or indirectly put, not even the litigant alone, because we are discussing representation of a particular senatorial district. You are punishing the voters, the eligible voters who were at that primary, who made a decision, whose decision you should have respected as the court. That is the decision you should respect. You should find out what happened and respect that decision. And then the court somehow decides to give itself another direction. Because at the end of the day, you have not, that question about who actually got the majority of lawful and legal votes have not been resolved. And I think that is what is hanging. That is the crux of the matter in most of these cases, not just this one alone, where technicalities have supplanted substantial justice. Now, if you look at the Electoral Act, it talked about the methods of nominating candidates, whether you are doing direct primaries or whether you are doing the delegate system or whether you are doing consensus. And it also talks about the fact that you have to notify INEC and they have to come there. It's mandatory to see what happened. You did a primary, you did not cancel it, you did not give any reason for attempting to cancel it, and the person now you're even saying had won did not participate. In fact, at some point it's understood he withdrew because he was looking out for something else. He wanted to be a presidential candidate. And when he fell, he now ran back. You did not cancel the first primary. And of course, the second you purportedly held was not observed by INEC. So where exactly is the foundation for declaring such a person? Are you supposed to be running for the presidency and Senate seat at the same time? I mean, this is ridiculous. Can't somebody make up his mind where he wants to be? And for him, talking about victory for democracy. So let us allow him. He could have been the presidential candidate and the senatorial candidate. This is the height of greed on his part. Because we even understood he didn't even proceed further. And he's now talking about a victory for democracy. So I think it should be clear to anybody that the courts should properly direct themselves on the question, on the issues in dispute. What has happened is like a student who the teacher and the examiner set an examination for. And he went into the classroom on the examination day and decided to set an examination for himself and answered the question and now starts rejoicing that he has passed the examination. Who set the examination for you? Nigerians, just like we are the masters, we are the employers of the president. We are the employers of the legislator. We are also the employers of those who serve in the judiciary from the Supreme Court down. And the mandate we gave them is clear. This is jurisprudential. It is beyond anybody thinking he has ultimate powers. We are saying, what mandate did we ask you to do? What did we ask you to do? To delve into technicalities or to determine who actually had the lawful and legitimate votes? And that's the question. If you have allegations of a crime or fraud, issues that are in dispute, you should come by way of writ of summons. I mean, since you need to take evidence, because originating summons is like we all agreed on the facts. We simply want the court to pronounce on the legal issues. But should that overtake the substantive question? Should the procedural question come first before the substance? What was at stake? Was it the form of the originating process? Or was it, I won the primary, so I'm the candidate? You affirm that you won the primary, you are the candidate. That is the question before the court. Any other one is like leaving the question, like I did say, simply walking into an examination hall, somehow ignoring the questions that were set by the examiner, proposing a question for yourself, answering it, and affirming, which has nothing to do with the original question set by the lawful authority, which is the examiner, and then simply shouting Eureka. The law is what the judges declare to be law and nothing more pretentious. But of course, law is written in English language, and all of us went to school. And beyond those sitting in the bench, other lawyers are just at the bar, and other Nigerians can understand what is going on. I don't think when professionals begin to mystify and technicalize otherwise very simple things, that's what leads to problem. There is nothing in the world that is so technical that an ordinary literate fellow cannot look through it and, try to understand what is happening. The sense of justice is a natural sense God implanted in all of us.
There are signs that we should not over-celebrate President Buhari's promise and move to hand over power peacefully yet. What are those signs? Correspondent Nasiru Usman attempts to go deeper in our closer look this Sunday.
It is 12 days to the first election, the presidential polls, in the series of elections leading to the change of government at different levels of Nigerian polity. The Independent National Electoral Commission, INEC, has ended the collection of permanent voter cards as provided in its schedule of activities for the conduct of the elections. However, many Nigerians, not by reasons of their own fault, but because of challenges in INEC processes, did not collect their PVCs. Apart from process inefficiency, there are complaints that political interest inflated the process to deny some targeted citizens the right to cast their ballot. The Lagos State Resident Electoral Commissioner, Rec. Olusegun Agbaje, has acknowledged that some permanent voters' cards may not get to the voters. He points to late printing of the cards and failure to follow the rules.
The challenge we have is that many people that ought to have done transfer last year did double registration. And by the Commission's guidelines, anybody with double registration cannot get another PVC because it's assumed that it's already having one PVC. The only area we have majority of people in that category is Oshodi, particularly at Okota in Oshodi, local government area.
Some of the affected citizens reason differently.
Look at the number of people here. Some have been coming here for the past 2 weeks from the ward level. They told them that they should come is at the local government level. This is also the sort of local government secretariat where this mammoth crowd is here. crying for their PVCs. It's not, they will come to the social media, they will come to the media, they will tell them that people don't want to go and collect their PVCs. This is a crowd of people waiting to collect their PVCs and they don't want to use their PVCs. Please, federal government should do something. INEC chairman, do something.
Last week, the chairman of Independent National Electoral Commission, INEC, Professor Mahmoud Yakubu, has expressed fear that the current unavailability of premium motor spirit may affect the movement of the Commission's sensitive and non-sensitive electoral materials to their various offices across the Federation, logistics for staff, and transportation of security personnel if the issue of fuel scarcity is not resolved.
The truth is that our arrangements may be negatively affected by the non-availability of products. Election is the largest deployment a nation periodically undertakes, and mobilization of vehicles for election is a large and complex exercise.
President Muhammadu Buhari has, however, pledged that nothing will change the scheduled elections.
As a 78th anger, there will be a new face at this podium speaking for Nigeria. Ours is a vast country, strengthened by its diversity and its common values of hard work, enduring faith, and a sense of community. We have invested heavily to strengthen our framework for free and fair elections.
3 state governments, Kaduna, Kogi, and Zamfara, has dragged the federal government to court over the alleged hardship their people are going through over the currency swap of the old Naira notes for the newly designed ones. The Supreme Court on Wednesday ordered the CBN not to put an end to the use of old Naira notes on 10th February as earlier announced. A 7-member panel of the court led by John Okoro gave the order of the interim injunction amid acute scarcity of the newly redesigned 200, 500 and 1,000 Naira currency notes. Hours after the Supreme Court judgment, a coalition of civil society addressed the press and later converged on the CBN headquarters, demanding that the Apex Bank should not extend the deadline any further. According to them, corrupt politicians are trying to get an extension to undermine the election. What and where are all these signs leading to?
Jihar Kaduna duk mai tsohon kuɗi ya je sayayya, ku gaya ma kowane ɗan kasuwa ya karɓi tsohon kuɗi Nasiru ya Rufai da Uba Sani da Asiwaju Bola Ahmed Tinubu sun yi muku alƙawari in har an zaɓe mu wannan tsari za a canza shi a ba kowa iyakan lokacin da ya kamata ya canza kuɗinsa.
What I expected that the government would have done was not to give a deadline, but find a way to withdraw the old notes as transactions go on. People carry out buying and selling all the time. So you make sure that you tell banks that, okay, if people bring old notes, make sure that if you're to pay, you're paying now with new notes. In that way, you can take off all the old notes from the market without causing any form of chaos at all.
This is the final resolution of the civil society that the February 10th deadline already set by the Apex Bank is irrevocable and irreversible. There are people who do not cherish free and fair elections. They desperately need money because they must buy votes.
To compound the situation and further make the 2023 elections rather shaky, 13 out of the 18 political parties in Nigeria have threatened to withdraw from the polls over the Naira redesign policy of the Central Bank of Nigeria, CBN. They insist that there should be no change in the date to end the use of old Naira notes. If these political parties make good their threats, the 2023 elections would be in jeopardy and may become subject of legal contention. Its credibility will also be questionable.
Supreme Court is the biggest court, is the apex court, is the highest court of the land, and Supreme Court has spoken. So that has overridden. Well, I'm even looking forward to these parties now saying that they are withdrawing from the participation. So I see it as grandstanding.
what the 13 political parties, supposedly, because those who addressed the press were just about 5 of them, but they are claiming that they have 13 of their members. But what's the political relevance and significance of these parties? Are they the major opposition parties? Would they have mattered if the election were to hold?
The signs are at best bad, but some may say ominous with these challenges gathering on the eve of the elections. There is bright lining on the situation. President Muhammadu Buhari has pledged to leave office in May, and he is making good his promise by setting up a transition council. Neither the judiciary nor politicians should put a spanner in the works. In Abuja, Nasiru Usman for Signature Show.
It is the second year after the End SARS nationwide protests, which pitched Nigerian youths against the government. But it seems nothing has changed after all since then. Did the nation learn any lessons? In enforcing the law, has the relationship between the police and the citizens improved, as cases of extrajudicial killings are still being reported?
The victim died as a result of police bullets.
Don't run, you don't need to. You are protected. A bit of altercation there.
Because they say, why go crack gun say one shoot?
There were about 10 cases or more of police extrajudicial killings in 2022. The high-profile ones include the Christmas Day shooting by a police officer attached to the Ajah police station of a 41-year-old pregnant lawyer, Bolanle Rahim, under the Ajah Bridge in the presence of her husband. Another victim, Godsent Ohafoso, was allegedly killed by a cop on August 13, 2022, during the burial of his master's late mother in the Shan Northeast local government area of Edo State. Oliver Ezra Barawani, a graduate of Taraba State University, was driving with his boss, Liu, a local government chairman, before he was killed by a cop. The victim was allegedly shot by a cop at checkpoint in Banti Napo, near Jalingo. On May 23, 2022, a journalist, Toba Adedeji, was covering a protest when he was shot by a trigger-happy policeman in Oshobo, Osun State. Emeka Uwalaka, a National Diploma Civil Engineering student of the Federal Polytechnic Nekede, Owerri, Imo State, was allegedly shot on July 11, 2022, by a policeman attached to the Nekede Police Division on his way coming back from church that fateful Sunday afternoon. The detention of innocent Nigerians and parading them as suspects against their fundamental human rights still persist. Now, According to the 1999 Constitution as amended, Section 36 guarantees presumption of innocence of suspects until proven guilty by a competent court of law. These are the issues we will interrogate in our conversation this Sunday with the Executive Secretary, National Human Rights Commission, Barrister Anthony Ojukwu, Senior Advocate of Nigeria. Please stay with us. You're welcome to the conversation.
Thank you.
Well, when you listened to my introduction, I did mention that this is almost 2 years after the NSAS protest, and I did ask, has any lessons been learned? Has the Nigerian nation learned any lessons in that nationwide protest?
Well, when we are talking about lessons, there will be lessons from the side of the police, there will be lessons on the side of the authorities, there will be also lessons on the side of Nigerians. Let us start with the Nigerian police. I know before the NSAS protests and the panels that were set up to probe the SARS protests, what used to be the popular slogan between the police and the citizens was, "I'll deal with you and nothing will happen. I'll kill you and nothing will happen." But today, I don't think anybody's hearing that kind of, statement anymore. However, it doesn't mean that violations have stopped. What has happened is, where there are violations, you can see accountability coming. You can see the case last December where some innocent citizens were extrajudicially executed while coming back from church service. Immediately the Inspector General of Police got them arrested and they are facing prosecution right now. That is what we need to see. Before, it was not like that. And you could also see that during the NSAS, all the allegations were investigated. Some of them have been referred for prosecution, some for disciplinary action. Compensation has also been paid. So, one thing that is changing in that side is, if something happens, there are going to be consequences, unlike what it was before. Now, on the side of the people, I can say, well, let me still dwell a little bit more on the side of the police. I must say that violations have also continued since after the NSAS, since after the panels, and even since last December when IGP is prosecuting the officers involved in that extrajudicial killing. Others have also happened. So the question is, these things that keep happening, does it mean that what we've done so far is not having any effect? Well, I don't think that would be a correct interpretation. It is having effect, but maybe not as holistically as we would want it to be, or not as fast as we would like it to be. Because if you check, even in comparison with other areas, other countries in the whole world, violation has never stopped completely anywhere, even in the most advanced democracies. However, what is expected is that we keep improving our response to issues like this. Certainty of accountability is what you used to know developed societies. So for us here in Nigeria, we say don't violate human rights. But if you dare do so, there will be consequences. Will come after you. The law will come after you. So that's the same thing we say for law enforcement officers who violate human rights. The other issue is the issue of any lessons learned on the side of the citizens. Yes, you'll find out that the rate of reporting cases of violation has increased. Why? Because people now feel that if they report, something will happen, action will be taken. Unlike before, when there was total disillusionment and people felt even if you report, nothing will happen. That is no longer the feeling of the people. I think there's some confidence restored in people now that if they take up complaints against violations like this, that action will be taken by the commission or CSOs or some form of government authority or the other. Now, on the side of government, which is very, very critical, action is also slow, in the sense that I would have expected that the agencies like the police, like the Human Rights Commission, like NAPTIP, like Ministry of Justice, that are fighting for people's rights will get a better funding to help them to fight this cause. Because you don't know which human rights violation is going to come tomorrow. So if you starve these agencies of funding, and if you look at these agencies, they are the least funded in the national budget of 2023. The funding of National Human Rights Commission, NAPTIP, Ministry of Justice, these are very, very low compared to their colleagues. So one would say that the challenges in the area of human rights, the challenges in the area of violation of the rights of people and committing crimes has not elicited equivalent response from the government authorities, because I think we can do better.
Okay, before we really dwell more on the area of funding, many Nigerians have expressed dissatisfaction in the quality of the Nigerian police, especially in terms of education, training, and social orientation. Do you think this is a challenge that needs to be addressed?
Of course, this is all part of our recommendations for police reforms. Yes, we blame the police, but we also need to look at what is it that is making them not to perform optimally. The recruitment is a problem. The qualification of those serving in the police is a problem. The training for them is the training, access to training is a problem for them. Also, the equipment, the infrastructure they need to work. Ordinary CCTV camera is not there. So the police battles with a lot, and for us to see an overall improvement of the performance of the police, which is what police reforms is all about, we need to be able to address all these issues sincerely with commitment over a period of time. Because issues concerning societal values, issues concerning training, issues concerning provision of infrastructure, they take time. They're not a day's event. It's a process. But we need the political will to consistently invest in this area over a period of time before we can see substantial change.
The attitude of the Nigerian police in the respect of human rights of Nigerians somehow can be attributed to probably their course curriculum and the content of the training manual they have in training school. Do you think there are things that needs to be added in this training manual, or are there gray areas that needs to be strengthened in the course curriculum for the Nigerian police in training?
Well, what we say is we need to mainstream human rights completely into the training curriculum of the Nigerian police. And even after training them, we need to leave a constant reminder. For instance, when you undergo courses for promotion, it's not enough to introduce it at the first point of entry into the Nigerian police. It has to be a condition precedent for you to be promoted. So in promotion courses, in promotion exams, human rights should be a pillar that every police officer must pass before he can be promoted. And those who also excel in compliance with human rights should be rewarded. There should be incentive for officers who show exemplary adherence to human rights in carrying out their duty. So it's very important that the training curriculum has human rights totally mainstreamed into it. But more importantly, the origin of the Nigerian police is still haunting it. Because the Nigerian police force was established by the colonial masters to help them oppress the people, enforce collection of taxes. So it was not pro citizens, it was anti the citizens. And that is the psyche we have not been able to change. Now we're in a democracy. In fact, law enforcement agents like the police are supposed to be protectors of the people, helping to protect their rights. So it is sad that they are amongst the highest violators of human rights.
So the oppressive mentality is
still overflowing into this period. So it is something we need to work on their conscience, to work on their psychology, to reorientate them to see themselves as there to protect the people now, not to oppress them. We need to do that. Unless you do that, the trainings we are doing will be across purposes. Because if they see themselves from the beginning as oppressors of the people, and you are teaching them human rights, they think that human rights is antithetical to law enforcement. Instead of seeing it as reinforcing, they see it as divergent. So if there's human rights, is against law enforcement. If law enforcement is applied, is against human rights. It is not the case. Both of them are supposed to be mutually reinforcing each other. So that is the mentality we need to get them to flow with.
You made mention of putting it in the consciousness of the Nigerian police instead in terms of training on human rights. Now, according to Police Act Section 68, subsection 3, states that in every police division, there must be a police officer who practices the law, who needs to keep reminding the police officers to be compliant with the national human rights. Is it what the practice is as of today?
Well, I'm happy that the law, the new Police Act, has taken into consideration, cognizance, the fact that respect for human rights is core to policing. Now, all of us must put our hands on the deck to make sure that we translate what is on paper into reality. But, like I said, this is not a day's business. We are going to do this through constant training and constant, evolving of policies and programs to make sure that this is a reality. And this can be done in several ways. Training is one of them. Constant interaction with the National Human Rights Commission is right now we have a human rights police dialogue where we deal with common issues of human rights that affect both institutions. Constant interaction with the civil society so that they also know that they owe a duty to the citizens. Is not only a regime protection, protecting people in authority. That is not the main duty of the police. The citizen is why they are. It is the taxpayers' money that are being paid with. So they need to see the citizen as their primary obligation, just as the Constitution says, that the welfare and security of the citizen is the primary purpose of government. So the protection of the citizens of this country, the respect of their rights, is the primary duty of the Nigerian police or any person in government, not the other way around. It is not the protection of people in authority or government officials or the police. That is not the primary essence of government. The primary essence of government is rather the other way, for those who are governing to protect the citizens.
You know, when you were talking, you rightly mentioned that cases of extrajudicial killings also happen around the world, but the difference is that there are stronger institutions that make sure you don't get away with any of it. But there seems to be lack of accountability in the Nigerian force today, when cases of extrajudicial killings or the police officers not respecting the human rights of Nigerians happen, the police authority seems to shield their personnel affairs. How can we address the challenge of, accountability in the Nigerian police force?
You are right in the sense that the principle of spirit de corps, and that is because police has not been able to see itself primarily as there to protect the people. That mentality of we are there to protect the government in power, we are there to oppress the people. So even if we violate their rights, it doesn't matter. So if a police officer violates the right of a bloody civilian, what the hell is that? So, but if it is the other way, that the primary responsibility is that of protecting the citizen, when you now do extrajudicial killing, then it will be seen as a primary duty to hold you accountable. So it's all a matter of reorientation, reacculturization, so that we shift the emphasis from the government in power to the citizens. Then it will become obvious that if you violate the right of any citizen, if you extrajudicially execute any citizen, it is the highest offense you can commit, and therefore there must be accountability.
Some people are saying that the reason we are having this trigger-happy attitude and mentality by the Nigerian police force, some have welfare and poor remuneration to that. What can you say?
Well, I don't think, yeah, a hungry man is an angry man, they will say. But when you are in the police, you are supposed to be a professional. That's why you undergo some training. It's a regimented service. You're not just like anybody, walking along the street. So you should be able to have rules of engagement. You must have rules before you use your arms. And as a professional, you ought to keep those rules. So you cannot say because you are hungry, therefore, any man you see on the streets, you shoot. Having said that, we think the issue of welfare of officers of Nigerian police force needs to be seriously looked into. Because outside being a police officer, you're also a husband to a wife, you're also a father to some children, you're also an uncle, you're also a member of a community where you have to fulfill your obligations. They're not going to waive you. Let's say your neighborhood is contributing money for fencing the neighborhood or paying even security for the neighborhood. They're not going to exclude you because you're a police officer. Your children have to go to school. They will not remove school fees from your own children.
Because your father is a police officer.
Because your father is a police officer. Your wife is going to go to the market to buy food for children. So we must bear all those things in mind. That policemen also have blood flowing in them. So we need to also address those issues that bother them.
Okay, finally, before we wrap up the interview, there is another aspect of this human rights violation by law enforcement agencies. Section 36 of the 1999 Constitution talks about presumptions of innocence. But now our law enforcement agencies parade suspects, and this contravenes the Section 36 of the 1999 Constitution. What would you have to say about that?
It's horrible. This issue of parading, we have talked and talked and talked and talked about it, and it's not abating. You see, that is wrong by the police. Even the courts have decided on the fact that it is prejudicial to parade people, because the Constitution says you are innocent until proven guilty. So, what reason will make you to parade somebody to the public that this person has committed an offense? But I think police is succumbing to public pressure to show that they're doing something. You know, immediately anything happens now, people will say, even nobody has been arrested, nobody has been taken to court. So police is under pressure to show that they have done something, but that is wrong. You cannot, while trying to do your job, violate more rights. That's another level of violation of the rights. So this is condemnable, and it needs to be stopped. And we should also be vigilant in protecting our rights. My advice is anybody whose right is violated in that way should be able to sue and get damages from the Nigerian police, because they have no right to parade you as a criminal until you have been convicted and found guilty by a court of competent jurisdiction.
Thank you. In the last 20 minutes or so, we've been discussing the Nigerian police and the respect of the national human rights of Nigerians. And of course, this is almost 2 years after the NSAS protest, and we've discussed if the Nigerian nation has actually learned its lessons. And my guest today was the Executive Secretary, National Human Rights Commission, Barrister Anthony Ojukwu, Senior Advocate. Let me thank you for being a part of the program.
Thank you very much. Thanks for having me.
Thank you.
Yeah.
And now for our thank you. Temilade Openiyi, professionally known as Tems, is a Nigerian singer born on the 11th of June 1995. She rose to prominence after she was featured on Whiskey's 2020 single, Essence, which reached the top 10 on the Billboard Hot 100. On 25th September 2020, she released her debut extended play, For Broken Ears. Now this Sunday, we present Temilade Openiyi, aka Tems, in Crazy Things. Sunday. Please follow us on all our social media handles displayed on the screen to get notifications of our program, and also to ask questions or make contributions. If you have missed any edition of the Signature Show, you need not worry. You can visit our website at www.signaturetv.org or our YouTube page to download the program. Please do not forget to subscribe, like, and share our page. Let's keep a date next Sunday. Thank you for investing your precious time with us. I am Marvelous Obonman. Good afternoon.